Oh, happy Tuesday, veterans, DKV employees. Hey, everybody out there. Hey, welcome to Veteran Lang, here where we talk about VA benefits and mainly compensation. On this educational platform, hey, we do appreciate you being here. We do know that you have plenty of other options out there to get your information about VA benefits and VA compensation. So we do thank you for flying with us. Hey, as always, I'm your friendly VA Attorney Matthew Lang, here for that other educational video for you. Hey, we got a major Federal Circuit decision from February 4th, 2026 that could change how AMA claims, the Appeals Modernization Act claims, and how just appeals are handled in general. Case is Hamill v. Collins. The court had held that under the Appeals Modernization Act, VA can no longer rely on the old implicit denial doctrine. So here's what that means in real life. Who it helps, and what veterans should do if VA never clearly decided an issue in your claim. So veterans, if VA never clearly decided one of your issues, but acted like it was denied anyway, that may be a much bigger problem for VA after this new Federal Circuit decision. And if you're in the AMA system, this case is going to matter. Because, again, on February 4th, 2026, the U.S. Court of Appeals for the Federal Circuit said that under the Appeals Modernization Act, VA could no longer use the old implicit denial doctrine. So in plain English, that means VA does not get to quietly bury a claim and then later argue that you should have understood it was denied. So let's break it down. I'm going to explain what happened to the case, what the court held, why it matters, where veterans get into trouble, and what you should do if you think VA never actually made a decision on one of your issues. Now, don't forget, as mentioned, this video is for general education only. It is not legal advice for your specific case, as every VA claim depends on the facts, the evidence, and the law that applies at the time. So before making decisions about your own claim or appeal, don't forget to consider speaking with an accredited representative, VSO, accredited claims agent, or accredited attorney like myself or others out there. If you're looking to speak with me about your claim and see how we can help, the best way is veteranlang.com, where you can schedule an in-person VA case evaluation here at the office here in Arizona, or if you're outside of the state, because we do help nationwide, veterans who live nationwide, you can schedule a phone evaluation as well. So let's start with the case. The case is Hamill v. Collins. As I mentioned, it was again decided by the U.S. Court of Appeals for the Federal Circuit, again on February 4th, 2026. I'll throw that link for that case down in the description so that you can read that as you desire. Definitely worth reading, in my opinion. The main holding was this. Under the AMA, a veteran's claim no longer can be implicitly denied. So veterans' claims can no longer be implicitly denied. Let's put it that way. And that's really how the court said it. And it was a key sentence. Now let's talk about what implicit denial means for those out there going, what's that mean? So before AMA, VA and the courts sometimes used a doctrine called implicit denial. The basic idea was that even if VA did not directly say, we deny claim number 2, a decision on claim number 1 might be enough to make a reasonable person understand that the second claim was denied too. Now, that doctrine was always dangerous for veterans. Why? Well, because the whole VA system is already confusing enough. If VA is allowed to say, well, we know we didn't clearly decide that issue, but you should have figured it out, well, that's going to create obvious problems. Veterans are going to miss deadlines. Veterans misunderstand what was actually decided. Veterans think an issue is still pending when a VA letter says it died years ago. And sometimes veterans don't even get a fair chance to appeal because there was never a clear decision to appeal from the first place. Now, this is exactly why this case is going to matter. Now, here's the basic background in Hamill. Mr. Hamill had and other than honorable discharge. VA had previously denied benefits based on the character of discharge issue. Later, he filed new claims again. The government did not really dispute that he was trying to reopen that character of discharge issue. But in the later decision, VA granted service connection for PTSD for healthcare purposes and denied some other conditions without clearly deciding the discharge issue the way he said it needed to be decided. So his lawyer later pushed VA to make an actual decision on the discharge character issue. When VA still did not handle that cleanly, he filed an extraordinary relief, basically asking the court to force VA to act. When the Veterans Court ended up treating the matter as mute, and part of the reasoning depended on the idea that the 2021 VA decision had implicitly denied the issue already, that is where the Federal Circuit stepped in. And this is the part you really want to understand. The Federal Circuit said the AMA changed the game. The court walked through the old implicit denial doctrine and then compared that older system to the structure Congress created under the Appeals Modernization Act, AMA. The court concluded that Congress eliminated that judge-made implicit denial rule when it enacted AMA. This is a very big deal because here's what it means in real life. If you're in the AMA system, VA should not be able to point to a vague decision on one issue and later say that another issue was secretly denied too. Now that's huge for veterans because the AMA system is supposed to be more structured. You have specific lanes, you have specific decisions, you have specific review options, you have deadlines tied to actual notice and actual decisions. And that only works if VA clearly tells you what they decided. So this is where veterans get in trouble all the time. They file for several issues, VA addresses some of them, VA ignores one, or VA partially addresses something but does not really decide the whole theory or the whole claim. Then months or years later, somebody says, well, that was basically denied. So after Hamill, that argument should be much harder for VA to make in AMA cases. So now let's be careful here. This does not mean every unclear VA action automatically wins your case. It does not mean every missing issue is now granted. It does not mean deadlines disappear. And it does not mean you should sit back and assume VA will sort it out on its own. What it does mean is this. If VA did not clearly decide an issue in an AMA case, there may be a strong argument that the issue is still pending, or that VA owes an actual decision before the clock can really run the way VA wants it to. So this is the practical impact. So who should pay attention to this case? First, veterans in the AMA system who filed for multiple issues and think VA skipped one. Second, veterans whose claim involved multiple legal theories and VA only talked about one of them. Third, veterans dealing with character of discharge questions, reopening issues, or procedural problems where VA's paperwork does not clearly match what was actually claimed. Fourth, representatives and advocates who have seen VA issue messy decisions and then try to clear it up later by saying the problem is the veteran's fault. Yeah, we've seen them all back here, by the way, veterans. We've seen them all. All five of those are big ones that we fight now, so keep that in mind. This case gives you a better framework ultimately to push back. Now let's talk about the strategy. What should a veteran do if they think VA never clearly decided one of those issues? Well, number one, read the actual decision letter and rating decision carefully. So keep in mind, the decision letter is the first part on top, and then the actual decision is the one with the big VA seal at the center of the top of the page. That's where that decision starts. Don't just look at the percentages. Do not just look at the combined rating. Do not just look at the list of granted issues. Look for what was actually adjudicated. What claims are listed? What favorable findings were made? What issues were explicitly denied? What issues were deferred? What issues are missing completely? Number 2, compare the decision to what you actually filed. That sounds basic, I know, but this is where people miss things. If you filed for 3 conditions and the decision only talks about 2, that's a red flag. If you raised a clear issue in a form of submission and VA never addressed it, that's a red flag. If VA addressed a piece of the problem but not the legal barrier that controls entitlement, that's a red flag too. Number 3, do not assume silence equals denial. That is exactly the kind of thinking Hamill pushes against in AMA cases. If VA did not clearly decide the issue, you may need to force clarity instead of guessing. Number 4, preserve your options anyway. Now this is important. Even though Hamill helps veterans, you do not want to rely on future court fights if you can avoid it. If a decision is unclear, get help quickly. Sometimes the smartest move is to file the appropriate review option on the issues that were clearly decided while also pressing VA to address the issue it missed. The mistake I see all the time is that people do nothing because they assume everything is still open, or they do the opposite and panic, fire the wrong thing because they assume everything was denied. Both can create unnecessary problems. Now, number 5, if you're dealing with an old messy procedural case, especially one in AMA, this may be worth a second look. Not every case will fit Hamill, but some cases absolutely will. Now let's talk about why this case is bigger than one veteran. This decision is really about notice, fairness, and accountability. Notice, fairness, and accountability. The VA system already asks veterans to navigate a very technical process. Deadlines matter, forms matter, lanes matter, evidence windows matter. And if VA gets the benefit of all that structure, then VA also has to do its part and clearly say what it is deciding. Now, that is the fairness point here. You should not lose a claim because VA left something vague and then later tried to reinterpret its own silence against you. That is what makes this more than a narrow procedural case. It goes to the basic question of whether the AMA system is going to function through clear decisions or through guesswork. And guesswork is where veterans get hurt. Now, I also want to say what this case does not do. It does not solve every notice problem. It does not mean the board or the regional office will suddenly become perfectly clear. It does not guarantee that CAVIC or VA will agree with every veteran who says my issue was never decided. There's still going to be fights over whether something was actually raised, whether the case is truly under AMA, whether another procedural doctrine applies, and what remedy is appropriate. But this is still a strong pro-clarity decision. And if you practice in this space, or if you're a veteran with a complicated claim history, you should know this case exists. Here's what VA employees, VSOs, claim agents, and attorneys should understand. For VA employees, this is a reminder that clarity matters. If an issue is before the agency, the cleanest path is to decide it clearly. For VSOs and representatives, this is a case to keep in your pocket. When VA tries to treat an undeclared issue as though it died in silence. For attorneys handling CAVIC or Federal Circuit matters, this case may become very important in disputes over pending claims, mutinous, appeal rights, and whether VA ever issued an appealable decision at all. Now, for veterans, the bottom line is simple. The VA never clearly told you yes or no on an issue in the AMA case. Do not automatically assume the matter is over. This issue may still matter. This issue may still be alive. And that issue may require VA to issue a real decision. Now, the final takeaway, Hamill v. Collins says that under the Appeals Modernization Act, VA no longer can rely on implicit denials. It's a very meaningful change. It gives veterans a stronger argument for clear notice. It limits VA's ability to hide behind ambiguity. And it reinforces something that should have been true all along. If VA is denying something, VA should say so clearly. Because veterans should not have to guess whether they lost. So, if you've had VA skip an issue, half decide an issue, or send out a decision that made no sense, this is exactly the kind of case you want to know about. Well, thank you again, everybody. This has been our talk about the Hamill case and the clarity that the VA needs to address. I thank you again for being here. Again, understanding that you have many places to get your information out there. So we do appreciate you again for getting that from us. Please don't forget to like, subscribe, share, and comment on the videos here. We do want to make the platform as engaging as possible and improve, ultimately, the system that is, well, currently broken, so that veterans and VA can have an efficient system in the future and make it easier for veterans to get those VA benefits that they ultimately deserve. All right, I'll see you again in the next video, and I wish you well. Thank you.